Well, hello everyone. Welcome to ABLA's latest in the series of webinars in relation to employment law. We come to you today from a stranger setting. Because of the deteriorating COVID situation in New South Wales, we're not in the salubrious studio anymore. I come to you from a bunker in the north of Sydney. And my colleague, Emily Slater, comes to you from the deep south in South Australia. So I imagine most of you, if you're in New South Wales, are at home, but I appreciate we're broadcasting far and wide today to places all over Australia, some of which are open and free and living their lives. So thanks so much for taking the time to join us today. We're talking about a fascinating part of our jobs, the general protections provisions of the Fair Work Act, and we're going to take you through some cases and talk through the jurisdiction. I'm going to click through to the next slide, and I might ask Emily Slater, can you take us through what we plan to talk about in today's webinar?
Sure, Jules. Today we're just going to run through a general overview of the jurisdiction. I think sometimes it's really good to get those reminders about, what are the workplace rights, how does it operate, what are the things that we need to be mindful of. We're looking at, what is adverse action, general protections claims more generally. We're going to run through some of the cases, a couple of recent cases, and how they tie back to some of the older ones, where we've got some interesting guidance from the courts. And at the end, we're going to talk about how to manage risk when it comes to these types of claims popping up in the workplace.
What are general protections? I mean, I've always been quite tickled by the actual name, general protections. There's a bit of David Brent to it. We're going to give some employees some protections. What kind of protections? General protections, warehouse types of protections. They're actually really specific, which is the irony about general protections, is that it's a really legal, heavily law-based part of employment law. And you might say that's an incredibly imprecise way to speak. But a lot of what we do in employment law is based on conceptions of fairness, unfairness. There's, in the Fair Work Act, there's literally the reference to a fair go. General protections isn't so much like that. It's quite specific, it's quite legally defined and quite exact, which makes it difficult and interesting for lawyers practicing in the area, but it also creates challenges for employers trying to navigate general protections claims that come through. In the broad sense, general protections are designed to protect employee rights, but specific rights, workplace rights. The workplace rights are probably well known to a lot of people on the presentation today. The right to take personal leave. The big one, which we'll talk about quite a lot, is the right to make a complaint or an inquiry in relation to someone's employment, the right to make a workers' compensation claim. But there's other general protections, and I guess this is where the generality comes in. Em, what are the other general protections apart from workplace rights?
Yeah, one that we see a lot is obviously up on the slide, protection from discrimination. So one of the sections in the legislation talks about an employer not taking adverse action against an employee because of a specific protected attribute that person may have, which are set out in the general discrim legislation that we see. So that's around physical or mental disability, someone's sex, family responsibilities, pregnancy, race, those types of things or those types of attributes that are protected by discrimination legislation as well, but also appear in the Fair Work Act. Another that we see quite a lot is temporary absence from work on account of illness or injury. There's a few claims that come through alleging that an employer has taken adverse action against an employee on account of the fact that they were temporarily absent from work. There's also freedom of association, so that's around union membership, engaging in protected industrial action and those types of issues that can come up, although less so in the context of a general protections claims. We mostly see claims around workplace rights, discrimination and temporary absence.
Thanks, Em. So I guess the question, if we're talking about general protections, what are people generally protected from? What is the protection? Now, the protection is against adverse action against another person or employee. Now, this is a simple part of the general protections world. Adverse action is exactly what it means: to treat someone adversely, to act in a way towards someone in an adverse way. But the actual protection only extends to adverse action taken because of a prescribed reason, including that person has a workplace right or has exercised a workplace right or proposes to exercise a workplace right, or because of a protected attribute that a person may have. Now, we're going to go into a bit more depth later on in this presentation about what that because test actually means and how it works. But to go to the simple part again, adverse action includes bad things that happen to employees and contractors and the people who are subject to the general protections jurisdiction. If you get your employment terminated, that's adverse action. If you're injured in your employment, maybe you're singled out, maybe you don't get a promotion, maybe you get too much work, that can be termed as injuring an employee in their employment. You could alter someone's position to their prejudice. Again, that could be a warning, that could be giving them a certain type of work or not giving them a certain type of work, not promoting them and so forth. And then finally, discriminating between the employee and their colleagues. This is the key one, and it's sort of oddly simplistic to say, Em, but there's no general protection on an employer taking adverse action against an employee, is there?
No, of course not. There's always going to be perfectly legitimate reasons why someone may need to be disciplined, including terminated from their employment, which is based on or related to their conduct at work, the performance in their role, or their capacity. I think the really key takeaway from this presentation today and general protections jurisdiction is that it's really, really important to ensure that the reasons why someone might be taking a particular form of adverse action, and it's usually steps leading up to termination of employment, to ensure that the reasons why someone is doing that is those reasons are not linked to or motivated by one of the either protected attributes or a prescribed reason in the legislation. So you wouldn't be terminating an employee because they are temporarily absent from work or because they have an illness or injury. And we'll do a bit more of a deep dive into that particular one because there are some exclusionary provisions, but it's really, really important to think about why are we taking the action that we're taking, and could there be an argument that the reason why we're taking this action is because the particular employee either has a workplace right or has exercised a workplace right or proposes to, or one of these other prescribed reasons. And the last dot point on that slide says, and this is just the way that it works, is that people who bring general protections claims will always link the adverse action, usually the termination of employment, but it can involve the giving of a warning or something else like that. They'll link that adverse action and the workplace right. So we'll often see employees say, I commenced employment and I raised a complaint against somebody, say for sexual harassment, or I raised a bullying allegation, and a couple of months later I was terminated, or it might be a few weeks later I was terminated. And that person may have been terminated for performance or some other reason that's completely unrelated to the complaint that they've raised, but the employee will try to link the terminating of the employment to the complaint that they have made. So it's really, really important. We'll talk about how you do this to be sure that the reasons why the adverse action is being taken is not linked to that workplace right or protected attribute. And I should also say, if people have questions, I understand there was a short video played at the start of the presentation today. If you've got questions, please feel free to send them through. If anything that we're talking about, you've got questions about any of that as we're going, please feel free to send those questions through as well.
Excellent. No, that's exactly right. Yeah, it's interesting, Em, in terms of the last dot point, individuals bringing claims will link adverse actions and workplace rights protected attributes. While it would be great for employers to simply say, well, you can't prove that, unfortunately, as we'll find out, they don't have to. As we will find out, it's the employer who will need to prove why they took the particular adverse action. So moving on. Now I'm going to throw you another question, Em. I'm going to ask it, and then I'm going to ask it in another way. And we haven't rehearsed this, just in case anyone's wondering whether we've rehearsed things when we're operating in different states and have so for months. Who can make general protections claims?
So basically anybody, well, we mostly see them from employees, but prospective employees can make general protections claims. Contractors, sorry, I was having a mental blank about how independent contractors can make a general protections claim. But of course, the most common claims that we see are claims that are made by employees. And we often see these claims being made in circumstances where an employee may not have completed the minimum employment period. So they commence employment, there may be some concerns that the employer has with their performance in those first few months that they've started. The employee may make a complaint in that time, or may raise a concern about, it could be their payment or potentially a relationship that, they may feel that they're being bullied at work. They don't complete the minimum employment period. Their employment is terminated for performance concerns, and the employee then brings a claim saying that the reason you terminated me is because I've made this complaint. So someone does not need to complete the minimum employment period, unlike with an unfair dismissal claim. They don't need to complete the minimum employment period to have been able to bring a general protections claim. The high income threshold is also unaffected by someone's ability, or their ability to make a general protections claim is unaffected by whether or not they're earning above the high income threshold. Also, procedural fairness considerations when terminating, they're generally irrelevant for the purposes of a general protections claim, although we certainly see in arguments demonstrating or allegations that an employer has engaged in adverse action for a prescribed reason, we often see that there are concerns raised about maybe the process that the employer's taken leading up to termination in support of an argument that that person was actually subject to that adverse action for the prescribed reason. And that's why record keeping, documenting everything, being really clear about that, and we'll talk about that later on as well. That's why that is so important. And I think a really strong feature that's coming to the fore in general protections claims is just how these claims involve the protection of complaint making in employment, and how that's a really strong theme that's starting to come through the cases, and we'll also talk about that as well.
And you didn't actually let me ask my follow-up question, which was, the first question of who can make general protections claims, and I guess maybe if you slightly change that to who does make general protections claims, you could equally answer that by answering the question who can't make unfair dismissal claims. And you've gone through them. People who never were employed, so prospective employees, people who are contractors, people who don't quite make it through probation, people who are, the 1% who are earning above the high income threshold, obviously far greater than 1%, but the high income threshold people, the senior executives are not making unfair dismissal claims because they're not in the unfair dismissal jurisdiction. So what can they do? Well, they can make a general protections claim because it's just not subject to those kind of rules and that kind of jurisdictional window. There's another good reason, there's another way the jurisdiction works, which we'll get onto the next slide. But it's also relevant, and I must say, I can't actually recall that we're going to labour the point, but unlike unfair dismissal, general protections does not have a jurisdictional compensation cap. So in unfair dismissals, you can get 6 months pay. That's what you can get. Now, 6 months pay is, depending on what your pay is, it's a chunk of change, certainly, if you ran an unfair dismissal claim and won and got 6 months pay. For adverse action general protections claims, not only is there not that 6 months cap, so it can potentially be far greater than that, but obviously there's no high income threshold jurisdictional issue either. So people can be earning far over the high income threshold, as well as being able to obtain a judgment of more than 6 months of their pay, meaning that, again, as I started with, this is a very legalistic part of the Fair Work Act. There's fertile ground for lawyers in that game, in an uncapped jurisdiction where anyone can make a claim. So let's go on to the next. Yeah, please.
Just before you go on, Jules, we have had a question come through. What about small businesses with less than 15 employees?
Yep. Do you want to take that?
I can definitely take
please,
that.
Go.
And
the
answer to that is there is also not that restriction. So if a business has less than 15 employees, an employee is able to make a general protections claim. So those exclusionary provisions, I guess, which operate from the unfair dismissal perspective, generally won't be applying in this jurisdiction.
I might, without wanting to get too philosophical, I might just unpack perhaps the reasoning for that and, again, compare it to the unfair dismissal jurisdiction, because that's where the less than 15 employees question has come from. The unfair dismissal jurisdiction is bound and is contained within a framework about a conception of fairness. What's fair, what's just. And obviously for a smaller business, they can't operate in the same way, and they're under different pressures and different restrictions than a big business, meaning that for an employer's perspective, it's not the same thing to dismiss from a small business perspective as it would be from a larger business. It's just you have to frame fairness in a different way. For general protections, I mean, we're talking about rights. We're not talking about fairness. And realistically, the way the general protections jurisdiction is created and set up is to try and give everyone the right not to be discriminated against, or everyone the right to make a complaint and not be, told to pack their bags because they're a troublemaker, and give everyone the right to be sick and take absences when they need to be sick. So I think that's the difference, and that's an important way of thinking about the whole jurisdiction, because we're not talking about getting to the right result because, well, fair's fair and this is kind of how it plays out, and that was a bit rough and off you go. We are talking about rights and people being able to exercise those rights, and that shouldn't really be affected by the employer's size, or necessarily even really be affected by the wider conception of harshness. Either you're acting for a prohibited and an unlawful reason, or you're not, and either the protection exists for the employee or it doesn't. So hopefully that wasn't too much of a hyperlink tangent, but let's continue on. Em, you were saying that generally we've seen a lot of adverse actions and general protection claims made on the basis that someone's made a complaint.
Yeah, and look, this slide really I guess we've covered this already in the presentation so far. That these are the most common ones that we see. And it's around this exercising a workplace right, or proposing to exercise it, or because they've made a complaint or inquiry in relation to their employment. These are the more common claims that we see being made.
You would also note that these are the more common claims being made, the ability to make a complaint is something entirely within the scope of the employee. So the employer hasn't done anything, the employee makes a complaint. Equally, a person's particular attribute, race, colour, sex, sexual orientation, age, etc., is not something the employer causes or creates, it just is. We'll get on to reverse onus in a few moments, but this is another important distinction between the unfair dismissal jurisdiction and general protections, is that general protections claims, or at least the basis for them, can be created by an employee. If an employee makes a complaint and they are subject to adverse action, as we said before, adverse action happens every day, they have a basis to make a general protections claim. Now, an employer may be able to disprove it, and we'll go on to how and why that happens. But general protections claims can be, essentially in the control of employees to lay the groundwork, which means a couple of things. It means employees who may, to use your probationary employment example, Em, who may feel like the writing's on the wall for them in terms of passing their probation, may see a general protections claim available to them if they make a complaint, and then they're subsequently terminated for whatever performance issues that they were having in relation to their probation. Now, I'm not saying that employees uniformly do that, or that there's any bad faith in any of this. But the point is that it's possible for an employee to actually create the basis for these types of claims, and without wanting to cast aspersions, it's also possible for lawyers or unions or people advising them to say, look, what would be helpful at the moment to put pressure on the employer is to make a complaint, and therefore they'll be worried about a general protections claim, and then you can apply leverage to them. In the same way, although for different reasons, if a person has a particular attribute, that can be used as a basis to make a general protections claim, which will need to be disproved as opposed to proved. So disproved by the employer as opposed to proved by the employee. We will get to that very shortly. I think I've buried the lead there. We've said that about 10 times, and we better get to the slide before long. But it's a very different framework in terms of general protections claims than unfair dismissals. So, Em, we've talked about workplace rights. Do you want to just take us through that slide?
Yeah, look, and we've included this in the presentation just to give, I guess, some legislative context to what we're talking about when we're sort of talking about workplace rights. We do this because it's sitting in the legislation, Section 341, and this section establishes that somebody has a workplace right where they are entitled to a benefit under a workplace law or workplace instrument. So an example of that would be, someone is entitled to make a workers' compensation claim if they're injured in the course of their employment. Same with B, they're able to initiate or participate in a process or proceeding. Again, that would be around, an example would be raising a safety complaint with maybe Safe Work New South Wales or something like that. It's establishing that these people have these rights. C is around making the complaint or inquiry. There's a fair bit of case law around this particular section, and we'll talk a little bit later on about how that is generally viewed in a quite a broad way, someone's ability to make a complaint or inquiry in relation to their employment. So we've put this slide in here so that there is some legislative context to what we're talking about, and I think it just highlights, that there is that statutory basis for this, and we're not just sort of talking about workplace rights in a dictionary sense, so to speak. There is a legislative meaning here.
Em, I might just jump to a question, which is a good one. Can you make a general protections claim even if you're still employed or only upon termination? I could be the cause of this question because I keep on going on about unfair dismissals. You absolutely can make a general protections claim while you're still employed. It's a different form. There's a slightly different way that the Fair Work Commission deals with it, but absolutely you can. And if you can think about the unpleasantness and the stress and tension of running a Fair Work Commission case against someone who you've previously dismissed, obviously when you're having to run a Fair Work Commission case or potentially a federal court case against someone who is currently your employee, very stressful, very unproductive. So this is another way that leverage is applied to employers, and another way that, to be honest, in a much less cynical way, another way that employees assert their rights that they have by making claims to say that I was treated adversely for an unlawful reason and it should either stop or be remedied. So good question. Thank you. Em, do you want to take this one?
Yeah, absolutely. So this section, again, we're just providing that context around what we're talking about from these parts or from these sections in the legislation. So Section 351 is the section which talks about the protected attributes. So this makes it clear that an employer must not take adverse action against, and again, this is employee or prospective employee, because of those discrimination, like your classic discrimination attributes. So someone's race, their sexual orientation, their physical or mental disability, family or carers' responsibilities. Interestingly, this section also establishes it doesn't apply to any action that is not unlawful under anti-discrimination law. So that operates to protect employers from these types of claims where they might be engaging, say, in some positive discrimination, because there would be provisions in the state and federal legislation around positive discrimination. Also, the really important one is section 3512B, which is where that action is taken because of the inherent requirements of the particular position. So if, for example, you have an employee who is, they may have been injured in the course of their employment, or they may develop a physical condition, or it could be, there could be a psychological injury there, whether work-related or non-work-related. If the employer is able to, on the basis of medical evidence and medical advice, establish that that employee can no longer perform the inherent requirements of their role, and that person is terminated on that basis. And again, you would go through a procedurally fair process before you would actually terminate, then that acts as a defence to a claim that an employer has taken adverse action because of the physical or mental disability. And that's why it's really, really important to get that evidence around inherent requirements. Just a question. Oh, sorry, Jules. Sorry, Jules, you were going to say?
Let's get to that question. I've looked at that question. It's a good one, but let's get to the question slightly later. I wanted to ask you about the 3512A, because I was thinking about a good example about this last night. Obviously, as you'd explained, you're not going to be able to make a general protections claim about something that's not unlawful within the framework of the anti-discrimination law that applies in the place where you're at. Now, begs the obvious question. The answer is discrimination laws are different by different states. Some things, you can discriminate in relation to some things in some states that you can't in others. And I was trying to think of an example of this, but in Victoria, there is a prohibition on discrimination as to physical appearance, which doesn't exist in other jurisdictions. So everyone likes an example. I think in Victoria, if you took adverse action against someone because they had a particular birthmark, you could have an adverse action claim on your hands. If that happened in another state, it might be an unfair dismissal. It might be some other thing, but you're not going to have an adverse action claim against you, because discrimination on the basis of birthmarks is not, as far as I understand, discriminatory or unlawful discrimination in somewhere like New South Wales in the same way that it is in Victoria. That doesn't come up very often. That where it does come up is where there is a particular discrimination law which applies to a particular state, and then the applicant has to make good a case that their employment was subject to the law in that particular state. For executive employees who occasionally make general protections claims, who are going all around the place, that can be a challenge. And there is an element of jurisdiction shopping in terms of those kinds of claims to try and get the jurisdiction with the most beneficial discrimination law, because not only do you get the benefit of the discrimination protection, but you can then make a general protections claim. The question, I think, which popped up was, do you want to, actually, I don't want to guess which question. You read the question and then we can answer it.
So there's actually been a few pop up while you've been talking as well, which I think relate to what you were just talking about. So we might go to those ones as well. One of them is, if an employee is terminated due to performance and given a payment to go, can they come back with a general protection claim? If so, is there a time period? I'll answer the last part of that first. There is a time period where an employee is terminated. They have a time limit to make a general protections claim, and that is 21 days. The first part of that question, I guess that would depend on whether they were given a payment to go, and that payment was subject to that employee entering into a deed of release. If that employee did sign and enter into that deed of release, then that would usually preclude them. Again, it would depend on the terms of the deed, but generally they would preclude an employee from making future claims against that particular employer. If they're terminated due to performance and they're given a payment by that employer that's not subject to a deed, then absolutely they can come back within the time period, the time limits that apply. But yes, they could absolutely come back and make a general protections claim. The second question that's come through, if a general protections claim fails, can an employee then make an unfair dismissal claim? The answer to that is no, and the reason for that is usually they're out of time to make the unfair dismissal claim.
And you've got to pick a lane as an employee. You've got to pick unfair or general protections. Occasionally we see general protections claims where we think this is just so unfortunate for this employee because they've either read the wrong thing or been given some bad advice. They haven't been discriminated against, or they haven't, the adverse action hasn't been performed on them because of a protected attribute or because of an exercise of a workplace right. Really, this might be unfair, but it's not general protection. So the time limits for filing the claims used to be different. So you used to be able to potentially try and get through an unfair and then later file a general protections, but now they're married up together, so you have to pick a lane, and it's one or the other. The observation I would make is that unfair dismissals are probably, in that they're slightly less formal, less legalistic, and there's the compensation cap. As an employer advocate and solicitor, I think they're easier to handle, and the risks are lower. I always feel slightly more relieved if you get an unfair dismissal rather than an adverse action claims. I don't know about you, Em. What's your thoughts on that?
Yeah.
You probably don't like getting either.
Yeah, but if you had to choose.
Yeah. Excellent. Let's go to the next question, the next slide. Temporary absence. Why don't we just gloss over this, Em, because I think we come to the temporary absence protection at the end of the slides. Or I know this is in your wheelhouse, the temporary absence provision. So did you want to cover it now?
Oh, look, I think just the point that we would make is, you can't dismiss an employee when the employee is temporarily absent from work. But there is no protection if the employee is absent for more than 3 months or a total of 3 months within a 12-month period, and they are not on paid personal carers leave. So I think that's really important, because you could have an employee who is a really long-term employee. They've accrued 6 or 8 months of personal carers leave during their extremely long period of employment, and something happens and they go off on personal leave. They are not temporarily absent even because they're on paid personal carers leave, even where they're absent for more than 3 months. So I think that's just a really important point to make.
And we'll talk about that in relation to Mr. Wildman in a few slides' time.
We will.
Em, I think we've covered the time limits. Do you want to just go through the timeline, not so much the time limits, but the timeline of how these are dealt with in terms of the commission? What can an employer who gets one of these claims expect in terms of the process?
Yeah, look, I think this slide is again just here to provide some information that people can refer back to. We go over the time limits. We talked about the 21-day period where an employee has been terminated. But for claims that don't involve dismissal, then you've got your usual statutory limitation period of 6 years. So, and look, we don't see a lot of claims, general protections claims, that don't involve dismissal, but you do see them. And obviously, as Jules mentioned before, extremely difficult where you've still got an employee who is still employed and in ongoing litigation against their current employer, and employers have to be really careful not to treat that person adversely in those circumstances, notwithstanding, obviously, they're being subject to a claim. So these types of claims will proceed through the Commission in a very similar way to an unfair dismissal claim. So the claim goes in, it must go in within 21 days or the 6 years if it's not involving dismissal. It's then allocated to a conciliator. There will usually be a conciliation. Settle at conciliation in a general protections application, then the applicant in those cases has the option of continuing the dispute in the court. So the Commission will then issue a certificate, and the applicant has, I think it's 14 days from the issuing of the certificate to commence or to continue the claim in usually the Federal Circuit Court. I think another really important point to make with general protections claims is what we're seeing a lot more of is these accessorial liability provisions come into play. So claims are made both against the employer being the legal entity, but also individuals who were said to be involved in the contravention. That's usually the decision maker in terms of terminating that person. It might be the person's manager, or it might be the HR manager. And as Jules mentioned before as well, we've got uncapped compensation, which is not, unlike with unfair dismissal, and the general protections jurisdiction is also subject to civil penalties, so they may also apply.
Excellent, thanks, Anne. This is the slide I want to talk about, the reverse onus. Now, this is really the key to general protections. This is why it's different from unfair dismissals. This is why it's different from a whole range of other legal processes. Let's go through the 4 dot points one by one. The reason for action is to be presumed unless proven otherwise. So very simply, if employee has exercised a workplace right, let's say they've made a complaint, and then they're adversely treated, as I said, adverse action, very, very common, let's say they're terminated. The employer will be assumed to have terminated the employee because the employee made the complaint, unless the employer can prove otherwise. Now, that is very different from other legal processes. There's probably quite good reasons as to why it's different. I mean, how an employee would go about proving the reason that an employer took adverse action if the onus was on the employee, it would almost be impossible for an employee to prove why the employer took an action. And so they flip the onus. The employer has to disprove that the action was taken for an unlawful purpose. Now, the last dot point 4, the applicant must still establish the objective facts given rise to the claim, including the existence of adverse action and the exercise of a workplace right, or the existence of a protected attribute. That sounds quite simple. It sounds like all the employee really has to do is demonstrate that they are adversely treated, and then demonstrate that they exercised a workplace right or have a protected attribute. Where it gets slightly more complicated is where there's a dispute as to whether it's a workplace right or not, where they actually had the ability to exercise the workplace right. And sometimes it can be a bit murky as to whether the protected attribute actually exists, and that's a question for the discrimination framework. But once the applicant does that, once the applicant can establish the objective facts that I was adversely treated and I exercise this right, or I have this attribute, the spotlight goes on the employer. Why did you take the action? And that will be up to the employer to prove. Now, there's a couple of things, and just noting the time because we want to go through the cases quite closely. It's not purely looking at the chronology. So a court will not say, well, just because the employee exercised their workplace right or made a complaint and then a week later they were terminated. That's not going to be good enough for a court to say, well, then that's definitely the reason. Equally, it's not necessarily a but-for test. So merely because an employee would not have been terminated if not for the fact that they exercised a workplace right, that isn't the test. The test will be, was the reason, the prohibited reason, a substantial and operative reason for taking the adverse action. Now, that's all very legalistic, but it really boils down to what was the reason that the adverse action was taken? What was the reason? That's what the court is going to try and determine. There was a strange line of cases some years ago that said the subconscious reason of an employer could constitute the reason. It's not the law anymore, thanks to the High Court. It is the conscious reason of why the employer is taking the action. And that's what the court will have to find out. They'll look at all of the facts, all of the evidence. They'll read all of the statements, all the affidavits from all the employees about what happened and why it happened. But ultimately, it will come down to a simple question of why did the decision maker make the decision that he or she did? And for employers, although the reverse onus of proof sounds really scary in that, well, this is completely unfair, it's all on us, and how are we ever going to disprove it? For the court, if you get the decision maker to provide evidence of what their reason was, and they're believed, that will be enough. I saw that you really wanted to say something. Can you jump in?
Oh, no, I was actually I was agreeing. I was nodding and agreeing with what you were saying. Sorry, Jules. I didn't mean to give that impression. I will say, though, that the cases that we're going to talk about next, I think really illustrate what you've just said as well, particularly your comment about it's not just establishing a chronology. And I think the first case we're going to talk about sets out really, really well why that's the case.
Let's jump to it then. Em,
right.
take us through Wong.
So we picked a couple of cases to talk about today, really on the basis that they encompass circumstances that we come across so often. And Wong and National Australia Bank, obviously this decision was just handed down last month. And it just really, I think, illustrates how an employer can successfully defend a general protections claim where when you look at the chronology of what happened in the lead up to this person being terminated, they can absolutely rebut the presumption and disprove what the employee alleges is adverse action because this person exercised a workplace right to make complaints. So in this case, we had quite a senior employee at National Australia Bank. Between January 2016 and March 2017, she raised a number of complaints that related to her employment, projects that they were working on. Some of those complaints were written, others were made verbally. They were complaints against, colleagues and people's ability to work within these projects. Around the same time, this person's managers were becoming quite concerned about her own performance and the way that she conducted herself at work. And there was some evidence in this case that she was an extremely difficult person to deal with in the workplace. Notwithstanding, she still did a pretty good job, I think, in a lot of cases, and she received that positive feedback. But there was also some discussions with her about their concerns. They raised these discussions with her more formally during performance reviews, and there were also casual discussions that the employer raised with her. So you've got this concurrent employer becoming concerned about performance and raising those concerns with her at the same time as the employee is raising complaints around the projects that she was working on and the behaviour of others at work and that sort of thing. In March 2017, it sort of came to a head. There were a number of complaints made about this employee. She was removed from her role, so they placed her on paid leave. And NAB advised her that it was considering her ongoing employment. She was given an opportunity to respond. They raised all these concerns with her. She effectively was put through a show cause process at that point, high income earner and everything else, but she was still given that opportunity to respond. In response to the show cause process, the employee raised even more grievances. So her grievances were then around that process. She said, I wasn't given enough information about the complaints. I don't know exactly what I'm supposed to be responding to here. But she didn't really address any of the performance concerns that the employer had raised with her. And ultimately, they proceeded to terminate her employment. There were some delay tactics that the employee went through. Her employment ultimately was terminated. Now, she commenced a general protections claim against the bank. alleging that it unlawfully subjected her to adverse action in contravention of Section 341A2, which we've got that set out on the slide previously, and she raised the accessorial liability provisions and that her manager was involved in the contravention. Of course, NAB denied this and said that its conduct was not motivated at all by any of the complaints that were raised during her employment. So chronologically in this matter, you can see that there are complaints that this employee is raising, and the employer is also raising its own concerns with her. So chronologically, it looks like, oh, I've raised complaints. Yes, they're talking with me about their concerns with my performance, but I'm also raising complaints, and then I get terminated. And then in the process of being terminated, I've also raised other complaints, and in response to that, the employer goes ahead and terminates. So in this case, the employer was able to successfully rebut the presumption. So NAB was able to demonstrate that it did not, that the reason why she was terminated and the reason why it removed her from the role, and there was another argument around it when it was removed from the role, when she was removed from her role, NAB announced her removal to the team, and she said that, look, that was another form of adverse action as well. So NAB was able to demonstrate that those actions that it took in relation to her were not motivated by the complaints that she had made. Now, the court said, yes, each of those three ways that the employee alleged she was subject to adverse action were adverse actions. So, of course, the terminating of her employment, but also removing her from her role, placing her on paid leave, and announcing her removal to the team. Those three elements did constitute adverse action. Also, by the employee making those complaints that she was making in the context of her employment, she was exercising a workplace right when she made those complaints. But the NAB was able to demonstrate that none of the adverse action that it took against her was because of the reasons that she alleged. And it's able to do that. These matters are really evidentiary. And so in this case, it talked to the decision maker. And importantly, in this case as well, one of the people that made the decision in relation to this person's ongoing employment didn't even know that she had made those previous complaints. So that was helpful. But also the evidence that NAB had, so it's written evidence and documents that it had kept records of conversations and file notes and things like that, were able to demonstrate that in its mind was its concerns around her employment. And so the court was satisfied that the bank did not contravene the Fair Work Act in any of the ways that the employee alleged. And I think that's a really good case that demonstrates how important it is to keep contemporaneous records around discussions that you have with employees, concerns around performance, and not just have discussions with employees about those matters, but keep notes and keep records and, you know, a performance improvement plan if necessary, and those types of, or that type of documentary evidence that can really support an employer in the event that the employee turns around and makes complaints, which often happens, and the employer wants to take steps to terminate them.
Yeah, Em, I mean, to summarise, NAB had written the right things, then said the right things when they went to the hearing, and they were believed. And so in terms of that, to go back to the reverse onus of proof, it's nothing to be scared of, and it's not rocket science to disprove the allegations, but you do need to provide an evidentiary case. You will need something in writing that is consistent with a lawful exercise of your powers as an employer. So you can't have anything in writing that says that you were acting unlawfully, or that could be said to undermine or compromise the position you put at the hearing. But ultimately, if you say you did something for the reason that you did it, and it was a lawful reason, you can be believed, and you can discharge that onus.
Yeah, and I think particularly when it's backed up by evidence.
Absolutely. I might just ask you to make a couple of very brief comments on Shay, because I'm just noting the time, and there's some good stuff coming up. So,
yeah,
Shay, it's an older case, and I guess this is a case which really was about a complaint, which it's about what a complaint is.
Yeah, and it without going into all of the background facts, the court in this case had to consider what constituted a complaint in the context of making a complaint or inquiry in relation to your employment. So we've included this information here because it's just a really good summary of how broad, even though, and we should also make the point that this case was appealed, and on appeal, in addition to these points that are made in the next two slides, I think that the key about the appeal was that the court was quite comfortable that a complaint can be something which is very, very broad. And that's the intent of the legislation as well. So really, you know, it's got to be a matter of substance, a genuine complaint. It doesn't necessarily in and of itself need to be substantiated to be a complaint that's protected, because someone may genuinely hold that belief or hold a view about a matter, even though you know, that's not able to be substantiated ultimately. And I think the purpose of these next two slides is really just about demonstrating how broad a complaint can be, and the court will support an employee's right to make that complaint or raise a grievance about matters that concern the employment.
Just be very, very careful before you start seeking to go after employees who've made a complaint because they've made a complaint, because they have a protection, and that protection is quite broad, which we've covered there. Why don't we jump to Wildman, and just again noting the time and noting that we have a couple of good conclusion slides. This is a classic, Wildman.
Yeah. Look, this is, again, a recent decision as well. I know you've got a lot that you want to say about this case as well, Jules, but I mean, I can just briefly run through the background.
Here, let me do the facts, because I like the facts of this. And obviously, if this company or Mr. Wildman is in the extraordinarily large audience we have today, please don't hesitate to put in a question. So we have an employee who had an underlying health condition. I think it was rheumatoid arthritis. And the employer started a conversation with that employee about relocating them, I believe from Bella Vista to Rose Hill in New South Wales. The employee wasn't that keen on that move, and fairly soon after these conversations started, went on a period of extended sick leave. Now, this employee had a lot of sick leave, a great amount of sick leave, and he covered his extended absence on sick leave. What did the employer think was happening, Em?
So they thought that he was really disgruntled about the change to his working location. Even though the employer was providing genuine medical certificates, the employer made an assumption, which is something we always caution against doing, made an assumption and suspected that actually this employee was abusing his sick leave entitlement.
So he had hundreds
without justification.
Yeah, he had hundreds and hundreds of hours, and they thought, well, this is all about Rose Hill. He doesn't want to go to Rose Hill. But then what happened? Yeah.
So they tried to almost immediately after getting the first medical certificate, the employer tried to engage with the employee's treating doctor to understand the reason why he was unfit for work. Now, that was extremely premature in the circumstances, and there was a great deal of correspondence back and forth. Now, the employee responded to that by not responding, and instead the employee engaged a lawyer. Now, in a way that it was probably to the employer a little bit like a red rag to a bull, and that just helped to, I think, cement in the employer's mind that, look, this employee is not genuinely unwell. He just doesn't want to go to work at Rose Hill. He's abusing his sick leave entitlement. And look, there was multiple pieces of correspondence where the employer was open about the fact that it was concerned that the employee was abusing his sick leave entitlements, which was obviously problematic from an evidence perspective. And what they tried to do was engage with this employee, meet with him, direct him to attend a medical examination. And this was all within sort of the first 1 to 3 months of his absence. And so it was very, very early for an employer to start doing that. Also noting that the employee was on paid sick leave, and there was no evidence in this case that the employee's absence was creating any sort of operational issues for the employer, which would have possibly supported more an argument that this direction to attend an independent medical examination was reasonable in the circumstances. There was just no evidence about his absence having any operational impact on the business. That's not to say that it wasn't, but there was just no evidence about that. So ultimately, the employer was summarily dismissed.
And of course, unbeknownst probably to the employer, or at least ignored by the employer, is the fact that the employee had a mental health issue, and that was the basis of his sick leave. He certainly was extremely premature to ask for him to make that out, and he was entitled to take sick leave. He had accrued sick leave. He had a medical condition which rendered him unfit for work, and ultimately was terminated. Now, the case is a fascinating case to read, and I would encourage all employers who are on the line to read the case, because it touches all the pressure points of what I know is a bugbear for all employers in terms of how to manage sick leave, how to manage people on long-term absences. But basically, it's a great example of why the process from an employer perspective is the way that it is. Why you don't automatically assume that someone is unfairly or inappropriately using their sick leave. Why you don't assume that they're not really sick. Why you don't assume that they'll never be coming back in some cases at the end of these kind of scenarios. So while there was an argument that the employer had in this, ultimately, after assessing all of the materials before the court determined that the reason why he was dismissed was because he was on sick leave, and he was continuing to take sick leave, and he intended to continue to take sick leave for as long as he was sick. That's quite a bad result from the employer perspective, to understate it. It really goes to this question of whether you can discharge the reverse onus of proof. You have to say the right thing, you have to have the right things in writing, and unfortunately in this case the employer just didn't. And it demonstrated, or at least the court was satisfied that it demonstrated that the reason this person was terminated was because they had taken sick leave, not because their absence was causing some operational problem, which Emily's just referred to, or not because they couldn't perform the inherent requirements of their role, but because they'd actually taken sick leave. So again, the test, the substantial and operative factor was the taking of the sick leave. And do you want to just talk about, quite quickly noting the time, the key takeaways for the absence on account of illness or injury?
Yeah, I think this is just, it's a really complex area. A lot of, exposure points come in with different types of claims that employees can make, where you're looking to manage an employee who is on extended sick leave, whether that's non-work related or work related. I think the one thing we're always saying to employers is be really careful not to make assumptions about whether or not an employee is genuinely unwell, or jump to any sort of conclusions about the reasons for their absence. And I think particularly in circumstances where they're providing valid medical certificates, an employee does not need to disclose the nature of their illness early on. I mean, obviously, the longer an absence goes on for, there are some other provisions that come into play, but it's really important not to jump to conclusions. Any direction to provide further medical evidence must be reasonable, and that is always going to depend on the individual circumstances in each case. Certainly don't engage in threats against an employee because they're taking personal leave, which is what happened in the Wildman case. And treat employees equally. If you've got policies, apply those policies equally to all of your employees. Comply with your own policy requirements around managing ill and injured workers. It's really, really important. Don't make assumptions or jump to adverse conclusions without having the evidence, without having further medical evidence.
So I'm going to jump to the slide that you're talking about, basically, and this is your general. These are the general rules, the general takeaways, and we'll close on this. You got to be clear as to why you're taking adverse action against people. I mean, we occasionally hear, well, we don't need to tell them. It's a casual employee. We don't need to give them a reason as to why we're not going to give them any shifts. If you don't give a reason, it opens you up to the allegation that you're acting for an unlawful reason, and you're going to have to disprove that. So if you've got no evidence, if you've got no paper trail, if you've got nothing, it's going to be difficult. Again, as Em says, act fairly, be upfront, be open, try to avoid any underlying motives. Occasionally, to the extent that if you're a higher level manager, you might have a lower level manager, a direct manager who's saying, well, this person's a troublemaker. I need to get rid of him. He's making too many complaints. Can't happen. Prohibited. So you need to manage those situations in a way that will mitigate your general protections risk and exposure. I want to jump to the last one, which is document everything. If it's not documented, it never happened. Now, that's a great Emily Slater line, and clearly she's written that. Obviously, you want to have a paper trail, but you want that paper trail to demonstrate a consistent and lawful reason for doing things. Be very, very careful, and I've spoken about the lower managers just a few moments ago. Be very, very careful that there is not something on your email system or in your notes or somewhere which suggests that the reason that adverse action is being taken is for an unlawful reason. Even if it's just a throwaway line or some doodling on a note paper in a termination meeting, if that's discovered in proceedings, it's going to be hard for you to disprove that that wasn't the reason or the actuating reason for you taking the adverse action. Think about what you put in writing, but as Em says, document everything so that you can, if a claim is made, rock up to the federal court or federal circuit court with your case to say, this is why we acted and it was for a completely lawful reason. Em, do you want to sum it up?
Oh, look, this slide really just sums up exactly what you've just said. Of course, you can always take adverse action against an employee. It's just really, really important to ensure that it's not relating to one of the prescribed reasons or the exercise of a workplace right or any of those reasons that are protected and would be covered by a general protection claim or would be relevant to a general protection claim. So I think, that's just important to be mindful of the underlying motivation.
Thanks so much for everyone tuning in today and for everyone who will tune in on YouTube when this no doubt goes viral, as it always does. My details and Emily's details are on the screen. There's a couple of very, very specific questions which we haven't been able to get to today. I'm happy for someone to reach out and contact us, and always happy for a chat. Thanks so much, Em, for all your help and for chatting today. Otherwise, everyone, please keep safe and be well.